Federal court reports are the authorised reports of the Federal Court of Australia, and that means that they are the repository and historical record of judge-made law in Australia, as authorised by the judges. And what that means is that, as we all know, we work in a common law system, and obviously that's all about the doctrine of precedent, and so judge-made law is the cornerstone of that doctrine of precedent. So the judges of the federal court, in authorising the reports, are not simply saying, here's an imprimatur to Thomson Reuters to go off and do whatever they like. They're saying that we guarantee you, the barrister, the solicitor, the other user, that these reports are, that the 210 volumes of the federal court reports are the body of judge-made law in our jurisdiction, the federal court, no more, no less. Now, what does that serve in Australia? It gives the practitioner the guarantee that all that judge-made law is there for them in one place. They don't have to look elsewhere for that. Well, I actually have only one criterion, and I imagine that most editors of authorised reports are the same. Given that we work in this common law system, and given that it is a precedential system, if a case makes law, it gets reported, and if it doesn't make law, it doesn't. That's the one criterion that I apply. Perhaps a little trickier to do than say, but that's it, yeah. There are three key factors to look at, and let me give you a practical application to hopefully help make it clear. Let's say that you're a barrister and you have a case that involves, say, misleading or deceptive conduct under the Trade Practices Act, and maybe the question of whether misleading or deceptive conduct may be constituted by silence. Obviously, as we know in the modern world, you can take those keywords and you can feed them into the undifferentiated databases that are out there. And what will you get? You'll get 2,000–3,000 cases. Now, what are you going to do with those? You don't know which ones are precedent-making that involve law. You don't know which are factual. The ones that do involve the law, you don't know if they're relevant to your case. You don't know anything. You're just sitting there with 3,000 cases that you have to try and read. Well, you can't do that. Or you can try, but you won't get very far in terms of being a good advocate. However, if you put the same catchwords into the database for the federal court reports, or if you use the old system going to the indexes and so on, you will pull up 20 or 30 cases on that subject matter. And you know, because they are the authorised reports and they only deal with law-making decisions, that you have 20 or 30 precedents. What's more, and here's the second point, you don't even have to read those 20 or 30 cases, because they each have a headnote prepared by a senior and highly experienced reporter, checked by myself as editor, and most importantly checked by the judges, to make sure that that headnote represents what they've said in their judgment. You can read those headnotes in half an hour, and from that you'll probably find 3 or 4 cases that are really on point for your argument. So the time you have available to you to prepare for the case can be spent reading deeply the cases that really matter to your argument, rather than trying to wade through a whole bunch of undifferentiated cases. And the third point of value that you will get by taking this path is that you know that the judgment that appears in the authorised federal court reports is absolutely accurate, because that is checked not only by the publishers and the editor, but by the judges themselves, to be certain that it represents what they said in the process of transcribing and taking proofs and printing and so on. The best example of this, I think, which was something that Mr. Justice Burchett, a former judge of the Federal Court, used to cite all the time because he was a great supporter of the concept of authorised reports, was, I can't remember what the case was about, but it doesn't matter. The point was that he said somewhere in that case that X is not the law. Now, when he got the transcript as came to him by way of proofs, the not had been left out. Now he's checking that, and so he sees that. It jumps out at him because it's horrendous. So he puts the not back in. In the authorised reports, it says that X is not the law. But of course, as no one is checking where it appears in the unauthorised series, it says that X is the law. The very opposite of what he was trying to produce. So if as a practitioner you want to try and use an unauthorised series, you're going to, from time to time, run in, perhaps not quite that dramatic, but you will run into problems like that, which you won't do if you use the authorised series. There's a case called O'Connor v. Adams in volume 210, I think page 364, from memory, recent volume of the Federal Court reports. And that's an extradition case where a man was convicted in absentia in Indonesia, an Indonesian citizen, for fraudulent acts which carried a life sentence. And then the Indonesian government sought to have him extradited from Australia. And I think it's a really important case and really interesting, not only from a number of technical legal points of view, but because the full court had to balance the needs of giving whatever assistance one should give to a member signatory country of the extradition treaty, in this case Indonesia, against what Australian views are of a fair go, if you like. In this case, a man being convicted in his absence for a crime that for us would probably carry a much heavier penalty than we would have in this country. So I found that personally, because when I was in practice, did a lot of criminal law, I found that personally, the most interesting case of recent times.